Today's docket may have lucked out because we keep getting calls from lawyers wanting to know about tomorrow's with the forecast of a whole possible inch of snow. But so you all are safe. Call the first case, please.
Seth County v. Knox County Board of Zoning Appeals et al.
We'll hear from the appellant.
Good morning, Your Honors, and may it please the Court. My name is Daniel Sanders. I'm here on behalf of Seth Downing, who is the appellant in this case. I've reserved 5 minutes of my time for rebuttal. Your Honor, this case is here on an appeal of a Rule 12 motion to dismiss and the Court's granting of that motion against the plaintiff. And the case is an appeal of an administrative decision. Mr. Downing is a property owner in Knox County. There's a development going in next door to him, 32-unit apartment complex. He challenged that through the available administrative proceedings. Knox County's adopted a zoning ordinance. Those development plans go through an application at the Planning Commission, and then there's an available appeal to the Board of Zoning Appeals, and then you can appeal to court. Mr. Downing appeared at the Planning Commission to oppose this development plan. He was not successful at the Planning Commission. He then filed a timely appeal to the Board of Zoning Appeals. And that's where the case gets interesting. Knox County has, in addition to adopting the procedure for appealing these, has inserted an opt-out provision in its ordinance. And the opt-out provision essentially gives the developer and the developer only an ability to opt out of a timely appeal filed with the Board of Zoning Appeals. And sort of back up here in a minute. That ordinance is at the center of this case. Once the Planning Commission makes a decision, any aggrieved party can appeal. And you appeal those by filing a form at the Office of Code Administration. Once that form is filed, you get on the BZA docket, and normally you'll have a hearing, public hearing. BZA conducts its business in public. This ordinance, adopted in 2022, gives a developer the right to opt out of a BZA appeal by sending a certified mail letter to the Knox County Law Director's office. Once the Knox County Law Director's office receives that letter, something happens and the BZA removes the case from the docket, and the ordinance says that you have to file your appeal in court. Now, court will understand the difference between an administrative appeal to the BZA being de novo and a court's review under certiorari being limited to the appellate record, or the appeal before the administrative body, the record before the administrative body. And so Mr. Downing claims that violates his constitutional right, that procedure of allowing a biased party that's financially interested in the proceeding to say, you know, I'm going to deprive you of this de novo appeal, deprive you of the opportunity to make a new record, and I'm going to force you into a limited standard of review under certiorari.
And so that's a declaratory judgment action?
No, Your Honor. That is an appeal under certiorari. And to be frank with the court, this ordinance throws a lot of chaos into the mix, right? It's not clear exactly what's going to be appealed, right? Is it an appeal from the BZA? Is it an appeal from the Planning Commission? Is it both?
But in this case, you are wanting us to say that the ordinance is unconstitutional, correct?
The relief that we've requested in the complaint is requesting that the court rule that the Planning Commission acted illegally or the Board of Zoning Appeals acted illegally, and that's the relief requested.
And the only way we can do that, though, is by saying that the ordinance is unconstitutional.
Well, you look at the ordinance and you determine whether the BZA, by enforcing the ordinance, acted unconstitutionally. And I think there's some confusion in the jurisprudence around this issue, and this declaratory judgment is the first issue that's raised. The trial court ruled that some part of our complaint was a declaratory judgment and dismissed that case out at the outset, and there is some case law that says that's the appropriate thing to do because there's a distinction between declaratory judgments and administrative appeals. And be that as it may, the distinction's there because you have a record in one, an administrative appeal, and you have a legislative act under a declaratory judgment. Well, what happens when you have an administrative body who follows an unconstitutional ordinance or an unconstitutional statute? I think you get both, right? You're not limited to saying, man, I am just out of luck in this administrative proceeding because the statute is what it is or the ordinance is what it is. I'm limited here because I've referred to that as the Nuremberg defense. I'm just following orders. The administrative body's just following orders.
But the declaratory judgment part would be only as to whether or not that statute, that ordinance was unconstitutional.
And so, right.
And if the answer to that is yes, then what happens?
So I think the distinction is as much the nature of the relief sought as much as it is the
I understand,
separation.
but the question is, what if the decision is that the ordinance was unconstitutional, the declaratory judgment part, what happens?
Well, you get damages, you get prospective relief.
What do you get? Does it go back?
I think it
Okay.
would go back, but that's not the relief that you're requesting in the declaratory judgment action. I think in the declaratory judgment action, you're seeking prospective relief, for instance, where there is an administrative decision made.
I understand,
Yeah.
but I just want to know, because it sounds like your complaint had a part that was a declaratory judgment saying, hey, this ordinance is unconstitutional. And my question, I'm just trying to make sure I understand what happens if the answer to that is yes. Do you ever get to your writ?
I think yes, I think we get an appeal before the Board of Zoning Appeals. The appeal gets reinstated because it was unconstitutional to allow a biased private party to essentially cut off the right to appeal the BZA if it was timely filed, and et cetera. And that's under the certiorari in the separate declaratory judgment action, we get a prospective relief in joining the county from enforcing that ordinance in the future. And so that's a distinction that we rest on. I've got limited time. I need to get to this verification issue. The trial court dismissed the remaining part of this case because it found that the verification on the complaint was not properly verified. Verification appears in volume 1, page 7. It's reprinted at page 11 of our brief. I signed the verification. So here, quite candidly, I'm here on behalf of my client and a little bit on behalf of myself because you read this statute. The trial court held that the verification did not strictly comply with Tennessee Code Annotated 27-8106 because it was not signed personally by the plaintiff and it did not reflect the personal knowledge of the plaintiff. Well, statutory interpretation, you have to begin with the language of the statute itself. The defendants here don't really analyze the language of the statute, and I'll read it to the court. It says, the petition for certiorari may be sworn to before the clerk of the court, the judge, any judge of the Court of General Sessions, or a notary public, and shall state that it's the first application for the writ. The statute contains no express directive that the petitioner sign the petition. The legislature could have done that. In fact, it did specify before whom the writ must be sworn to. It doesn't expressly require the verification. It does require that the petition be sworn to before certain individuals, and it doesn't expressly require that the verification be stated on personal knowledge. Now, legislature could have done that. We cited some other statutes where there is either a personal knowledge requirement or a personal knowledge requirement and a certain signatory requirement. I think you can look at those statutes to see whether the legislature has done that in this case. But ultimately, I think this case turns on the Supreme Court decision in Talley versus the Board of Professional Responsibility. In that case, I think it does double duty. The court considered it subject matter jurisdiction in that case. It held that a verification on a writ of certiorari that verifies the complaint is true to the best of the verifying party's knowledge, information, and belief, meets the requirements of Tennessee Code Annotated 278106. And where you have that language being approved by the Supreme Court, knowledge, information, and belief, that's clear that there's not a personal knowledge requirement, because under Rule 56, where courts have analyzed whether an affidavit is based on personal knowledge, they say, well, if the affidavit says knowledge, information, and belief, there's no way to determine, whether any part of the affidavit is on personal knowledge. So I'm over my time. I'll get back to that in rebuttal.
You have your time for rebuttal. Thank you. We'll hear from the appellee.
Good morning. May it please the court. My name is Richard Graves. I represent the defendant and appellee, Sergei Bodazat, but I'll be presenting the argument jointly on behalf of all defendants.
You'll be, you'll be the only one arguing.
Yes, Your Honor.
Okay, fine. Go ahead.
No contentions with how the procedure was discussed here, or in terms of how we got here. I would note that the plaintiff filed an original complaint. At that point, the defendants jointly moved to dismiss, predominantly on the same reasons that we have laid out in our joint appellee brief. In part, most notably, that many of the actions call for declaratory relief, and second, that the verification of the original complaint was not adequate. There was a hearing on that in the trial court, and the trial court, before ruling on that, gave an opportunity to the plaintiff to amend his complaint to cure the declaratory judgment issues. And subsequently, the plaintiff filed the amended complaint, which is the operative complaint here. And the substance of the changes, the plaintiff went from alleging that the opt-out provision was illegal for various reasons to alleging that, well, the BZA's actions in following it operated to be illegal or the opt-out provision operated to be illegal for the same reasons. And that would be the plaintiff alleged that it was not authorized by state law and that it violates various constitutional protections. And, I think there's no dispute on all sides that actions for declaratory relief to invalidate an ordinance and actions for certiorari to challenge administrative action should not be joined together. I would note that in the amended complaint in paragraph 28, the plaintiff acknowledges that the plaintiff did file a separate action for damages, declaratory relief, and injunctive relief in federal court for the purposes of challenging the opt-out provision. That complaint was attached to the joint motion to dismiss that the defendants filed. So it is in the record. We asked the trial court to take judicial notice of it. I don't know if I would say the trial court explicitly did or did not take judicial notice of it, but it's in the record. And I would note that in terms of distinguishing an action for declaratory judgment versus administrative action, the Tennessee Supreme Court in the case McAllen v. Memphis set forth the test for distinguishing these two causes of action. And an administrative action is an action that executes a law already in existence, whereas a legislative action is an action that creates a new law. And here, plaintiff's cause of action challenging the BZA cannot succeed unless this court determines that the opt-out provision that was adopted by the Knox County Commission is illegal. The Knox County Commission is not a party to this proceeding. I think a lot of the analytical framework that this court needs to employ has already been done by this court in the recent case of Greer versus Fayette County. That's cited extensively in our brief. And that case involved a development application. I don't recall the particular county. Well, Fayette County, it's in the name. But that case involved a local ordinance, I believe it was just called Section 13 in that case, that purported to allow, I think, solar fields in an agricultural zone. And there was a proposed development for a solar field that a lot of neighbors opposed, which is not an unusual situation and a similar dynamic here. There were 2 lawsuits that made their way to the Court of Appeals. One was the TAP case that's cited in the Greer opinion, and I don't recall if that was a 2022 decision or 2023, but the TAP decision alleged that Section 13 of the local ordinance was illegal because state law did not allow that particular zoning power to occur. In this court, in the TAP case, held that that ordinance was legal. There was a rational basis for that. Now, in Greer, the very similar parties to that first case challenged via writ of certiorari the administrative action of the zoning board in relying on that Section 13. And I just want to read from the court's opinion in Greer, because I think it's really the same situation we have here. And so this is a direct quote, though I do skip over some parts. Fatal to appellant's argument is the fact that the Fayette County Board of Commissioners enacted Section 13 of the zoning resolution and, in doing so, bestowed on the zoning board the power to do exactly what it did here. Appellants also argue that the trial court's refusal to nullify Section 13 of the Fayette County zoning resolution, which directly contradicts and is antithetical to a specific state statute, constitutes clear error by the trial court. Appellant's argument here is, in essence, a challenge to the legality of Section 13 of the zoning resolution, a challenge that is wholly unrelated to the gravamen of this appeal, i.e., whether the zoning board exceeded its authority. As appellees discuss in their brief, challenges to the legality of a zoning ordinance itself are properly brought under declaratory judgment actions. And the Greer court went on to hold Section 13 authorized the zoning board to do what it did. It followed Section 13. That's the scope of its jurisdiction. Power of the board upheld. And I think that's really instructive here for 2 reasons. One is, just like here, plaintiffs are now attempting to challenge the legality of the opt-out provision, but that's not before this court, regardless of how the plaintiff characterizes it. And secondly, plaintiffs call this the Nuremberg defense, but the plaintiffs fail to state a claim as to the BZA action because the face of the complaint shows the BZA did exactly what it was required to do under the opt-out provision. And the opt-out provision is not discretionary. It requires the BZA to dismiss an appeal.
All right, but you lost me there. The fact that it requires them to do it, how does that answer the question of whether or not that ordinance itself, what it requires them to do is constitutional or not? I don't think anybody denies that that's what the ordinance says.
Well, I think in fairness, as this court held in Greer, the challenge to the legality of the zoning ordinance is not before this court. So to your point, Your Honor, it may not answer the question of whether the ordinance is valid, but that question's not before the court in a certiorari action. And the question is, did the zoning board follow the rules before it? And here, the rule before it is the opt-out provision. The Board of Zoning Appeals followed it. And I would note that...
So they should have just filed a deck action on it?
They could have and should have. And I would say this is not a unique situation. Unfortunately, we didn't cite this case in our briefing materials, but there's a 2014 Tennessee Supreme Court case. And in that case, I can find it before the argument's over, that involved a party challenging planning commission action and essentially alleging that planning commission's denial of an application constituted a taking and requiring just compensation. And the Tennessee Supreme Court, in a footnote, rolled out the preferred course of action, where you have a dueling challenge of an administrative action and an original action. And the preferred course of action is you do both. In that particular case, one of the cases could be stayed pending resolution of the other, but that would be the preferred course. I would note that, in essence, here's what plaintiff would have the BZA do. As plaintiff would have it, the BZA was required to determine that the ordinance applicable to it is illegal and that it couldn't follow it. That invites chaos, and I would note that a case that the plaintiff actually cited in the reply brief. It's maybe a 1996 case from the Court of Appeals, reported decision, Hoover Inc. First Metro Board of Appeals. Very interesting case. There, a over half of a Board of Zoning Appeals recused themselves of a matter, and as the court determined, they simply just didn't want the heat from the community of proving an application that they knew met the rules, essentially. And so the court, when it's describing what these board members did, and a lot of board members just acknowledged that the application met the requirements, but they just didn't like that. They just didn't want it there. The court noted as follows, and this is a quote: "Board members who abstain because they do not believe the law is correct are, in essence, legislating. Allowing such action by board members is an unlawful delegation of legislative authority." As plaintiff would have it, he would have the Board of Zoning Appeals legislate by their actions of choosing which laws they want to follow or not.
Under your argument here, how could a individual in the plaintiff situation contest whether or not that ordinance was constitutional or not?
As soon as the ordinance was passed, the plaintiff, just as any other member of the public, could challenge it in declaratory action proceeding.
Oh, then? So long before the plaintiff is ever impacted by it?
Whatever the plaintiff wants.
Well, I'm just asking you,
Yeah,
if
sure.
in this situation, what could the plaintiff have done? How would you say, if there was any way for the plaintiff to argue that, hey, this ordinance itself is unconstitutional?
At a minimum, I think that would be challenging the legality of the ordinance before the BZA applies it.
I'm sorry, before?
At a minimum, I would say the best course of action for the plaintiff is to challenge that ordinance before the BZA even has a chance to apply it against his application.
Before the BZA dismissed it?
And again, I mean, there's a number of things the plaintiff could do, but I think that
I'm just asking. That's why I'm asking. You
Sure.
know, are you saying it should be a deck action just on that issue, or there's simply nothing plaintiff can do since the BZA did exactly what the ordinance said it was supposed to do? I mean, how does a landowner, how and when does a landowner have the opportunity to contest whether or not that ordinance is or is not constitutional?
Again, the plaintiff can challenge it whenever he wants. I'm not the plaintiff's attorney, but the best course of action from the plaintiff, from my point of view, would be to challenge that as early as possible before any other proceeding relies on it. And I would note that administrative appeals are supposed to be speedy resolutions, and that is in part to not tie up developments forever. I mean, they're statutorily entitled to a priority over other cases. An opinion, they have to be filed within 60 days. There are multiple equities on more sides than just the plaintiffs, but I would just very briefly want to go back to this verification argument. For a plaintiff to have standing to challenge an action, a plaintiff, and it's the plaintiff's burden to show, the plaintiff has to show aggrievement, which means that the plaintiff is affected by this development, or proposed development, in a way that's not common to the public generally. And the statute also requires that a verification or a complaint be verified by oath or affirmation. Now, it simply stands to reason that whoever signs that verification when they're verifying the facts as to aggrievement has to have personal knowledge of the unique harms that the plaintiff suffers that's not common to the public generally. And as a matter of logic, that really would simply just be the plaintiff himself. Yeah, I think the most, what I think the case that best illustrates the problems with having an attorney sign on behalf of a plaintiff is the Keystone insurance case that we cited in our brief. And in that case, an insurance company out of state sued a Tennessee resident trying to recover sums under an insurance contract. The defendant resident filed a motion for summary judgment alleging that the insurance company lacked the ability to do business in Tennessee because it lacked a certificate of authority or other legal authorization. And so in response, the insurance company's attorney filed an affidavit on the summary judgment materials. And the attorney in this affidavit said he was authorized to execute it on behalf of the company. And briefly, I'm running out of time, but I'm just going to read from this passage. While the attorney states he was authorized to make this affidavit on behalf of Keystone, we believe that such facts could be more competently stated by those within the insurance company who have firsthand knowledge of the facts. Experience proves that the adversary system functions best when the role of judge, of counsel, of witness is sharply divided. we cannot conclude it has been affirmatively shown that the attorney here is competent to testify to the matters stated in his affidavit. We believe the trial judge should have struck plaintiff's response to the motion for summary judgment. So granted, it's a summary judgment case, but I think the same policy concerns, the same practical concerns are evidence in this case. I did mention a case earlier, 2014, just before I end. That was the Phillips v. Montgomery case about the preferred procedure of dual challenges. Just for the record, that's 442 Southwest 3rd, 233. I would lastly note in my final 30 seconds, the appeal form in this case that the plaintiff initiated to go to the BZA. I believe that's on page 21 of the record. That appeal form was executed by the plaintiff's attorney, Brenda Brooks. She represented him before the Planning Commission. So on page 45 of the record, it's her letter to the Planning Commission. The plaintiff had adequate representation and ample opportunity to list his reasons for the appeal to the BZA, and the reasons he lists are not in the complaint. And the reasons in the complaint were not in that appeal form, and he waived them.
Thank you. We'll hear from the appellant in rebuttal.
Thank you, Your Honor. I guess I'll take this in reverse order. This issue of waivers have to be knowing and voluntary. There's no indication on this appeal form that the plaintiff would be waiving any issues by not including them in the 5 or 6 lines that are available for the reasons for appeal on the appeal form. There's no rule, statute, or other ordinance that says if you don't mention all of the reasons in the appeal form, then you're going to waive those. There's no prohibition, by the same token, there's no prohibition on amending that appeal form before the hearing or simply raising those issues at the hearing before the BZA, and so that's the waiver issue. This argument that it stands to reason, quote, that the aggrievement requirement requires personal knowledge on the verification is this sort of argument that, well, it just makes sense that the statute requires this. It's not an argument that the statute requires this. And so I would argue that it's more subtle than that. The defendants here are attempting to raise the aggrievement or relegate the aggrievement requirement from an evidentiary requirement to a pleading requirement. And that sort of stop it there. If there was an allegation that my client wasn't aggrieved by either the Planning Commission or the BZA, they would raise that issue in a motion for summary judgment, and the court would hold an evidentiary hearing on it or some sort of other evidentiary hearing. And I wouldn't be the witness there. I would call my client to testify that he's aggrieved by this. And so I think that's a misplaced argument. Perhaps Phillips versus Montgomery, perhaps the correct thing is to file this certiorari action, stay it, and then let the outcome be determined by whatever happens in the federal court. But to suggest that my client is just out of luck because he didn't file a deck action to challenge this ordinance when it was passed before he had any reason to know that it would even be applied to him is nonsense, right? It would be extremely unfair to say that, okay, my client has been dragged through this process. This happens to him. He feels like that it's not right, that it's unjust. But because the ordinance says what it says, the very thing that he's trying to challenge, this development that's going in next to him, well, he's out of luck. And his only relief is to file a deck action to have the ordinance declared unconstitutional and prospective relief ordering the county to not enforce it in the future. Well, how does that help him? That's essentially to deny him the relief that he's requesting. So back to this verification issue is where I left off. I think you go with this directly, and then you can come at it from both sides, is the way I think of it. The statute, which I read to you, does not contain a personal knowledge requirement. And an attorney in my position should be able to read the statute, the plain language of the statute, read a leading Tennessee Supreme Court case on the subject, and come up with a verification that complies with the statute in the Supreme Court. And what I attempted to do in this case was just that. I read the statute, I read the Talley case, and essentially copied and pasted from the tally case into the verification that was attached to the original complaint in this case. And it says, I verify that, or affirm that the complaint is true and correct to the best of my knowledge, information, and belief. And when the Tennessee Supreme Court has said, we have subject matter jurisdiction in a writ of certiorari case based on that kind of verification, an attorney should be able to rely on that and represent a client. And so you go at it directly that way, come at it from the side on tally. Tally says that knowledge, information, and belief is satisfactory. There is no case that says someone other than the petitioner cannot execute. There are cases that say the petitioner has to, but those aren't essential to the court's ruling in any of those cases. The Supplevated case, the complaint was not verified as true, although it was signed and notarized. In the Hurt case, which is another case that they cite, the complaint was signed as true but not notarized. And those are the two kinds of cases that you'll see. We cited to the Drainage District case, which is a 1917 case. It's an older case, but it gives us, the court, maybe a sense of what legislatures and courts were thinking around that time when this statute was passed back in the early 1900s. And an attorney was able to verify a petition for certiorari in that case. So my time is up. Unless the court has questions, I will submit to the court.
Thank you.
Thank you.
Our thanks to all counsel from both sides. We appreciate your briefs and your oral argument on this.